Mokgoatlheng.
No, I disagree, my lord. I'm sitting with a statement from Brigadier Ninava right in front of me, and I can read it to the court. He is from the policy, the head policy in the component governance, legislation and policy in the Division of Legal Services of the South African Police. He made this statement, and there's no authority, there's no section or standing order that he says this. I can read the statement into the docket. So if I'm being told there is an authority, I don't know where it's coming from, because this brigadier is from the policy division of the South African Police, and he says there's no policy that prescribed a specific form. It's a statement under oath signed by him, my lord, and it was, as I said, it was done last year.
Brigadier. Thank you, Brigadier. This is my time to cross-examine. If there's a need for whatever information that you have that the state feels needs to be placed on record, they will still have an opportunity in re-exam to place that information on record.
No, my lord, that may be true, but I cannot agree to an assertion that is not correct. When I'm being told I'm wrong when I say there is no prescribed policy or standing order that says a specific form must be used. How do I agree with that when I know it's not correct? I'm sitting with a statement of the custodian of the policy. He stated clearly he's the custodian of the standing orders in the South African Police, and he says, and he's a brigadier for that matter, there is no prescribed form in the warning statement. How do I agree with the assertion that is put to me? And I'm being told now, because I'm under cross-examination, that will be wrong of me to agree to that.
Brigadier, you have just said that what I put to you is incorrect. When I say you are incorrect, and you are saying to me, no, you are correct. In other words, when I say to you, you are incorrect, I am incorrect myself. But the reading of that information that you have, that will be in the domain of the state. Remember, I'm not here representing the state. Do you understand? Okay. And there's a procedure here at court. Unfortunately, on a number of occasions, that procedure has just been let to go the way in which it went. But what I'm putting it to you that now is that you are wrong when you say that there's no authority within the context of the South African Police Services that says that that prescribed there's no specific form that is prescribed by the South African Police Services, a form that should be used when a suspect statement is taken. I'm saying in that regard you are wrong. And allow me to proceed with my line of cross-examination.
My lord, yes, the advocate Mnisi can proceed, but I can't agree that I'm wrong when what I know, supported by the custodian of the standing orders, agrees with me. How do I say I'm wrong? Unless then I must refer to the state, to that authority. I don't know where it's coming from, because the statement before me comes from the custodian, a brigadier in the policy section of the police, and he says there is no prescribed form when you take a warning statement prescribed by the police. There's no such policy. How could I agree with what I'm being told, my lord?
Thank you. When you say you don't agree with me, I'm not saying you should agree with me.
Sorry, Mr. Mnisi. Otherwise,
maintain your position.
We're still going to go around. Can I have that document?
Yes, my lord, you may.
Because you're arguing about documents which you have, which I don't have. Can I have that document? Because you're talking about documents which were handed over. Sorry. Did you hand over this document to
the state advocate, my lord? That was last year.
Does the defense have it? Hello?
I'm just trying to...
Mr. Ramsepiri, do you have the document?
I can't remember if...
Okay, you'll have it.
Yeah.
I want to follow the argument.
My colleague says we did give them. We can mark it exhibit ZZ.
No, fine, I'll just read.
3.
I'll just... Because it also has what it calls an SAPM. But I'll just read what he claims to be the policy.
This is the relevant.
No. This one, which was being quoted by the brigadier. Yeah, this is the one you're quoting, eh?
Yes, my lord. Just that it is an attachment that I...
Yeah, I see. That's why I'm saying it is attached to this statement regarding interview with a suspect, which is called SAP 3M.
Yes, that's the one we're debating before court, my lord.
No, you're not debating that. Affidavit in terms of section...
Sorry, my lord, as the court pleases.
Yeah,
Maybe I need to bring the following to the attention of the court.
yeah.
Remember, the court is an arbiter.
Yes.
Now, when the court reads that document into record, there might be instances where the person who wrote that document, there are instances where that person who wrote that document may be required to come and testify.
Yeah, no problem. No problem. If you want him to come, no problem. I will issue the subpoena for you.
Now, what I'm saying, my lord, is let that document rather be read into record by the person who...
No.
Thank you, my lord.
You are saying there is no policy. You. He says he can't agree with you
No, my lord.
because there is a policy.
No, I am saying,
Yes,
he is saying there is no policy.
that's it. And you are saying
And I am saying to
He's
him,
wrong.
He is wrong.
that's it. So,
Yes.
as an arbiter, I'm
Yes.
taking the two composite assertions, okay? And I'm entitled to do that
Yes,
because you can't agree.
we'll never agree because
Okay,
this is
fine.
cross-examination, my lord.
Affidavit in terms of section
Yes.
234 of the Criminal Procedure Act. Can you just read section 234 for us?
Pertains to official documents.
Yeah, just read it so that we all are on the same page.
Proof of official documents. Section 234, subsection 1.
Right?
It shall, at criminal proceedings, be sufficient to prove an original official document which is in the custody or under the control of any state official by virtue of his office, if a copy thereof or an extract thereof, certified as a true copy or extract by the head of the department concerned or by any state official authorized thereto by such head, is produced in evidence at such proceedings.
Yeah, fine.
Subsection 2, paragraph A. An original official document referred to in subsection 1, other than the record of judicial proceedings,
Right?
may be produced at criminal proceedings only upon the order of the Attorney General. Then paragraph B, it shall not be necessary for the head of the department concerned to appear in person to produce an original document under paragraph A, but such document may be produced by any person authorized thereto by such head. Then subsection 3, any official who under subsection 1 certifies any copy or extract as true, knowing that such copy or extract is false, shall be guilty of an offense and liable on conviction to imprisonment for a period not exceeding 2 years.
Okay, fine. That's enough for the purposes of this court. This is said to be an affidavit in terms of section 234 of the Criminal Procedure Acts 1977. Peter Willem Ninabar states under oath in English, I am an adult male with ID number. He mentions the ID number. I'm 55 years old, employed as section head policy in the component governance legislation and policy in the division legal services of the South African Police Services, SAPS, holding the rank of a brigadier, and he mentions his telephone number. My duties at legal services inter alia include the following: drafting and maintenance of delegation documents, drafting of national instructions and revising of standing orders, maintenance of the database, version control and safekeeping of policies, national instructions and standing orders, and drafting of legal opinions for the management of the South African Police. I am the custodian of all policy, national instructions, and standing orders in the SAPS. On the 26th of November 2024, Brigadier Kininda made inquiries regarding policy or directives of the South African Police dealing with the South African Police 3M statement regarding interview with a suspect, also commonly known as warning statement. I indicated that I could not find a policy or directive of the South African Police specifically dealing with the completion of the SAPA 3MM form attached as PWN, the one which is attached here. Paragraph 5.1 of the National Instruction 6 of 2014, that is the Prevention and Combating of Torture of Persons, attached as PNWN2, inter alia deals with the interviewing of persons in custody and provides as follows. Every member must follow the following instructions when interviewing a person in custody. 1. Before the commencement of the interview of a person in custody who has been arrested for alleged commission of an offense, members conducting the interview must identify themselves and inform the person in a language he or she understands, A, of the offense in respect of which he or she will be interviewed, B, of his or her rights to consult with a legal practitioner or his or her choice, or should he or she prefer, to apply to be provided with the services of a legal practitioner by the state. C, that he or she has the right to remain silent and that anything he or she says may be used as evidence in a court of law. And D, of his or her right to apply to be released on bail. From the SAPS 3MM, Form SAPS 3MM contains instructions relating to the use and completion of the form. These instructions need to be followed when completing the form. It is my prayer that this Honorable Court take judicial notice of the above. I know and understand the contents of the statement, and I have no objection to taking the oath, and it is signed on the 17th of November 2024 at 10:15 by Brigadier the Camper. He is the authority who certified this. Can you give this also a citation? Yeah, you can continue, sir, if you want to continue.
The exhibits ZZ in brackets 1 in brackets B.
Okay. Yeah. Yes, sir. You can continue.
But certainly, I'm going to request
What?
at whatever point that this Nina Bagai should come so that
Yeah, no, you can come.
Yes.
Yeah, fine. You must call him. You want him here. You must call him.
Yes, I'm going to call him.
No problem.
Yes.
Because he is the head, according to him.
Yes.
Unless he makes an affidavit and he misleads this court. Because he says, I indicated that I could not find a policy or directive of the South African Police
Yes.
specifically dealing with the completion of Form 3MM, which is the form you guys are talking about,
Yes.
right?
Yes.
And this thing is akin, we've dealt with this thing. This thing is akin to, remember, I don't know if you recall, when we're dealing with the confessions. You remember the forms were not similar. Hello,
I was not involved in the confession at that point, my lord.
You remember?
Indeed, my lord.
Yeah, they're not similar. Mrs. Yoon came with a form. Mr. Colonel, yeah, the big gentleman, Limboto, they all came with different forms. But anyway, I'm not even making a finding, but I think all we're arguing about is Section 35. That's all. That's the premier law in South Africa concerning the rights of an accused person. So this is just recommendations. That's why even that document, which that gentleman in Khafreni says, the senior prosecutor says, it must be clear that you're dealing with section 35. And I'm saying, we dealt with thing in 1931. I was not even born then. And we also did this when we were doing this case of Seth Cooper here in this court. 1962, no, sorry, 1972, when Sasso, Steve Biko, and all those gentlemen were being charged. They had the same argument about what does this form say. And the judge, who was Feljun, he was the JP of this division, Boshoff, he said, no, what is important is the rights. These are recommendations. Once there are, and he gave us this silly example, if you come into a police station and you find that there is no document which is enacted in a form of a confession, you don't tell the guy, hamba. You can take a free page like this one. You can take a free page and write warning statement and warn the guy in terms of section 35. That document is valid. That's the law. Okay, fine, we can continue. Unless the doctor here. Doctor, am I talking?
I agree with the court.
I think it's more a question of substance over form.
Yeah.